Our next speaker is Domenick Carmagnola, President of the State Bar Association. Welcome, Domenick.
8 or 10 minutes. Most people that know me, I can't say hello in 8 or 10 minutes. So this is going to be a struggle. And I apologize for the raspy voice, but I enjoyed yesterday watching the Seton Hall Prep boys soccer team win their state championship. So that explains it. Good morning, everyone. As the chief said, I'm the president of the State Bar, and it's really an honor today to be representing the State Bar, which is the state's largest representative organization of judges, lawyers, and legal professionals. Chief Justice Rabner, honorable justices of the Supreme Court, Judge Grant, thank you for the opportunity to participate in this judicial conference on jury selection and to participate in what we view as an historic event as we examine the jury selection process, consider steps needed to prevent discrimination in the way we select juries, and recommend improvements to our system of justice. Chief Justice Rabner, I commend you. I commend you and the Supreme Court and the Administrative Office of the Courts for deciding to take on this incredibly important issue. To the extent it's not clear, I really need to make something very clear. We agree that a review and an assessment of the jury selection process is warranted, and that steps are necessary to reduce the effects of bias and discrimination on New Jersey's judicial system and its capacity to ensure fair and impartial trials. Please know that the New Jersey State Bar Association stands ready, willing, and able to work together with you in this endeavor. So as we begin this important endeavor, we must ensure that this historic moment is not wasted in the race for expediency. Chief Justice Rabner himself stated in State v. Andujar, and I quote, "It is important for the New Jersey judiciary to focus with care on issues related to implicit bias." Chief Justice Rabner, we heard your challenge as you started the conference to keep an open mind and to listen. And we've done that, and we will continue to do that. You noted that there are consequences to inaction and consequences to not being open to change. We understand both of those sets of consequences, as well as the critical importance of the issues that we're attempting to address. But we also understand that action for the sake of action is not the answer. And the wrong action could damage our justice system significantly and have dire consequences on the lives and the liberty of the participants in it. We agree that this is the time to act, but we must do so with the goal of getting it right. Because my time is limited today, I'm going to focus on a few important issues, but I do urge everyone participating today and watching to read the interim report that the NJSBA submitted to the conference. The report was prepared by an exceptionally talented and diverse group of trial attorneys who made up the State Bar's working group on jury selection, which was formed shortly after the Andujar decision was released. That report provides additional information, resources, observations on the issues being discussed at this conference, and really looks more expansively at the pathways forward. I want to publicly thank the members of that working group for their tireless effort to review these issues and to producing our report. But I really must single out Ray Brown and Mike Donahue, who did an incredible job of leading that effort and shepherding the report to its conclusion. I'm further humbled that the work and findings of the report have already been adopted by more than 20 bar associations around the state. And I'm proud to speak on behalf of those colleagues in the profession from our county, specialty, diversity, and affinity bars who not only adopted the report, but make up various aspects of our practice. As we've already come to learn from just over one day of testimony and panel discussions at this conference, the broad challenge of race and fairness in the criminal justice system in New Jersey is profound. And now we are poised on the cusp of a historic moment to balance the scales of justice for generations ahead and enact meaningful reform to address the systemic affliction of bias and prejudice in the jury selection process. The New Jersey State Bar Association and its members are unequivocal in their embrace of this reform and of the elimination of bias, including implicit bias in the justice system. The pursuit of a representative justice system and a determination of the best ways to rid our system of the harmful presence of implicit bias and prejudice in jury selection must include an expansive, thoughtful, and comprehensive analysis of the entire process, and not just a focus on peremptory challenges. As this has been discussed throughout this conference, an appropriate starting point is the means by which the pool of jurors is created. Greater diversity can most immediately be achieved by the expansion of that pool and by an examination of the persons who are excused from jury duty, as the Supreme Court has now required in Dangsel. A critical area of study should be the voir dire process and how courts address challenges, both for cause and peremptory. Peremptory challenges have long been regarded as the only tool available to Black and other criminal defendants of color to ensure unbiased juries. They are among the most meaningful of a criminal defendant's substantive rights. The use of peremptory challenges is often the only way a defendant has to level the playing field. They are a safeguard in a system that relies so heavily on a juror's self-diagnosis of bias. Even more importantly, the exercise of those challenges is one of the only truly participatory moments of a trial for a litigant. Through peremptory challenges, the defendant has the opportunity to directly participate in the selection of those people who will decide his or her fate. That is a critical aspect of a just system, and it is one that should not be eroded. As the Supreme Court held in Pointer v. US, and I'm quoting, "The right to challenge a given number of jurors without showing cause is one of the most important of the rights secured to the accused." Reducing peremptory challenges is not a panacea, and indeed, not even an appropriate incremental step at this stage to address the important problem we are all attempting to solve. It is premature to suggest a reduction or elimination of peremptory challenges until we try other available mechanisms to address bias and make our system more fair. The State Bar is committed to exploring changes that may be helpful in solving the problems identified in State v. Andujar. There are many things that can be done to make juries more representative, and several are explored in detail in our report. Among the recommendations in our report, and I'm sure you're going to hear some overlap as we go through this day, and speakers from different groups are up here. And Mr. Krikora said many of the same things that we support. We must reform the Batson-Gilmore standard, which is applied to for-cause challenges. We must make the law regarding for-cause challenges reflect the importance of rooting out jurors who cannot be fair, as has been done in other states. We must expand attorney-conducted voir dire. We must expand the scope and source of summoned jurors to produce a more representative panel. We must provide implicit bias training to all individuals who are part of the process, judges, lawyers, and jurors. We must gather demographic information as ordered in State v. Dangsel so that we can review and analyze it and its impact. Regarding the Batson-Gilmore reform, we believe it is the appropriate approach to remedy concerns regarding challenges that are discriminatory in nature. And you're going to hear this afternoon. California and Washington have already chosen this path by creating an objective versus subjective test, and the same has been proposed in Connecticut. New Jersey would be wise to review and analyze their experiences and to follow suit. Both California, and Mr. Krikora touched on this. Joe, thank you for that. Both California and Washington have reformed Batson to insert an objective rather than purposeful discrimination standard. The objective test set forth in those reforms modifies the analysis so that the inquiry is not focused on overt, purposeful racial animus by the party striking the juror. Using the objective test has the added benefit of reducing the legal friction by eliminating the accusatory flavor of the current structure. I'd be remiss if I didn't speak briefly about jurors who are summoned to the courthouse but do not get the opportunity to serve. I know I think we described them as the wasted jurors. As we all know and have come to experience, and as Professor Chernoff noted, not everyone relishes jury duty, and those who are not selected for juries may be inconvenienced, but they are certainly not wasted. We must change this perception of jury duty and find ways to encourage our citizens to serve and to properly compensate those who want to serve but would suffer adverse financial impact if they do. We must also be careful not to lay the blame for jurors not being used exclusively at the feet of peremptory challenges. Dr. Rose's data shows that most attorneys don't use all of their challenges, and the analysis presented fails to consider such factors that may result in a juror not sitting, including the inability to serve, hardship, an excusal for actual cause, a plea bargain, or a settlement, among other reasons. More importantly, we ask that the conference focus less on the number of people who are called but do not ultimately serve, and more on creating a justice system with juries that truly represent our communities. I think we would all agree that the idea of reducing wasted jurors is a bad one if the result is that litigants do not ultimately receive a fair trial with a fair, impartial, and representative jury. Dr. Glaude opened our conference with a challenge that we recognize and confront the gaps in our justice system. He confirmed and supported several requests that we make here today and in our report. He stated, quote, "Deal with the question in its fullest sense. Don't refuse to do this." We have asked that we look at the entire process and not simply make piecemeal changes. He also stated, quote, "If we are going to salvage our country, we have to be as deliberate in our efforts to dismantle racial inequality as we were when we built it." I'm going to borrow on that. And we ask, if we are going to improve our system of justice and the jury selection process, we have to be deliberate in our review, analysis, and efforts at reforming it. As I close today, I say with the full power and authority of our over 15,000 members and heeding those other bar associations around the state that support our report, that the legal community stands ready to be a full partner in the path ahead. We ask that, like us, you approach this effort with an open mind, and we sincerely hope these matters are not preordained and that this is the start of a meaningful journey to reform and improve our system of justice. Simply put, Chief Justice, while the State Bar believes there is no quick fix, we applaud the court and its effort to address these significant issues. We stand and remain ready to work with you in this noble effort. Thank you.
Thank you.